Good morning. We welcome everyone to our spring session held again via Zoom. We fully expect our courtroom proceedings, which we all miss, and look forward to resuming. We have a fairly long list today, so we'll ask counsel to help us move through the list as expeditiously as possible. These are basically single issue cases which we've selected for review. And as a consequence, the court's very familiar with the issue which led us to accept this case on our discretionary docket. We'll call the case, and then if you would allow me to say a few words to frame the issue, I would ask counsel for appellant to introduce themselves and begin the argument. Brian, would you call the first case, please?
The first matter is Caitlin Quigley versus the Unemployment Compensation Board of Review. Representing the board is Ms. Colleen T. Riley. Representing Ms. Quigley is Ms. Julia Simon Michelle.
Good morning again. This appeal arises in the administrative law setting. After receiving an award of unemployment compensation benefits, a claimant filed an administrative appeal to contest the amount of the benefits that had been awarded. Acting of its own accord, however, the Unemployment Compensation Board of Review found that the claimant was entitled to no benefits. In a divided opinion, the Commonwealth Court majority determined that the board exceeded the appropriate scope of its review and violated fundamental due process norms. In the present appeal, the employer contends that the board has the authority to consider all of the issues in unemployment compensation cases and challenges the Commonwealth Court's contrary ruling. Ms. Riley?
Good morning, Your Honors. May it please the Court, my name is Colleen Riley, and I represent the Unemployment Compensation Board of Review in this case. Today, the Board asked this Court for three things. First, the Board asked this Court to reverse the Commonwealth Court's decision because it allows parties to limit the Board's fact-finding power and what issues can be addressed on appeal. Commonwealth Court's opinion is in direct conflict with, one, the plain language of Section 504 of the law, which gives the board power over any claim if a party appeals a department termination. Two, this court's holding in Peak that the board has de novo review over any claim decided by a referee. And three, 35 years of Commonwealth Court precedent after Peak, wherein it repeatedly held that parties cannot pick and choose which parts of a determination the board can review on appeal. Second, the board asked this court to reverse Commonwealth Court's holding that blindness is applicable to the UC system. Instead, the board asked this court to hold that, one, the UC system is a fact-finding system in every level. Two, the board is the ultimate finder of fact and determiner of credibility in that system with the power to substitute its own judgments for that of referees. And three, department, referees, and the board do not act in an adversarial or prosecutorial manner when they adjudicate a UC claim by making findings of fact and applying the relevant sections of the UC law to the facts as found by them. And finally, third, the board asked this court to reverse the Commonwealth Court's novel holding that due process requires not only notice and an opportunity to be heard on an issue, it also requires a controversy between two parties at every stage in a UC proceeding. Commonwealth Court's holding was made without any citation to support it or legal authority. Further, the General Assembly has charged the board with ensuring the UC fund is used only for its statutorily intended purposes, so the solvency of the UC fund can be maintained for those who are unemployed through no fault of their own. The General Assembly set various eligibility standards throughout the UC law, and a claimant must meet each in order to have a valid claim and be paid benefits. In order to fulfill its obligation, the board must be allowed to review all issues addressed in a department determination or a referee decision if it is appealed by a party. The board cannot be expected to turn a blind eye to facts that may develop as a claim moves through the UC system if those facts show that the claimant is not, one, the General Assembly intended for benefits to be payable to. Therefore, the board asks this court to hold that if a party appeals a determination of the department or a referee decision, the facts as found by either are not binding on the board, and eligibility for UC benefits is always in dispute and is a threshold issue the board must and can address on appeal. In the framework of the Pennsylvania unemployment system, the General Assembly was the one that gave the board unusually expansive powers of review over claims, and those powers are found in Section 504 of the law. Section 504 is where this analysis must begin. It's plain I'm sorry, go ahead.
That's all right. It's Justice Bear. Can you hear me?
Yes.
We always try to give you a couple minutes to set forth your framework, but it seemed to me that you had done that and you were going forward. Is that fair?
I was setting forth the framework, and I was actually concluding it, and then I was moving forward. Yes.
Let me ask you something that I hope is just pedantic. You concede that UC is subject to the Constitution of the United States and of Pennsylvania, do you not?
Correct.
Therefore, if we would determine, as Commonwealth Court determined, that all your arguments and whatever the board is saying is a deprivation of due process of law, you lose, right?
If it's a deprivation of due process, I would have to agree with you. But in this case, there was no due process issue because this claimant had notice and an opportunity to be heard, and she chose not to avail herself of that situation. Therefore, the board.
Let's explore that for a second. Let me ask you a hypo.
Okay.
There's and I understand UC is different, but I don't know that it's different in terms of due process in the Constitution. There's a civil case, somebody rear-ends somebody else. It comes to court and the defense says, we concede liability. My driver bumped into the back of a moving car. We're here to fight about damages. They try damages, they write a number, they go to the Superior Court. Can the Superior Court say no liability?
I believe if the court has fact-finding power to decide the issue of whether or not liability is present, then if they cannot make the findings of facts to get to that determination, then I'm not sure how the court would come to a decision in that case, Your Honor.
Well, I would suggest to you respectfully the issue is not before them. But I think the same thing in your case. I don't think it's a question of fact-finding. I think it's a question of due process. Now, I may be wrong, and I might be in dissent. But it just seems to me that this was not in controversy. Went to the department did not contest, employer did not contest. Went to the referee, department did not enter an appearance and contest, employer did not contest. If I'm a busy referee and that case comes in front of me and I say, what's the issue? And they say, the amount of money that needs to be subtracted from UC because of the side operation. I don't say, well, you better prove liability. I would say, as I would in a civil case, fine, you owe comp, I'll decide the question before me, which this referee did. So on appeal, notwithstanding, quote, fact-finding, end of quote, I just don't see how this claimant can be prejudiced because she didn't prove something not in controversy. Do you follow that?
I follow what you're saying, Your Honor, but under Section 402H, the disqualifying provision for self-employment, it is a multifaceted section of the law. The very first issue that the claimant must prove is either that she is not self-employed or that she fits within the sideline eligibility exception. Therefore, the threshold issue in this case is the self-employment.
May I stop you for a second?
Yes.
And in this case, the other side comes in and say, I concede those two issues, but you still have to prove it.
I believe this goes to the fact that parties cannot agree on whether or not they're entitled to benefits, and in this case, it would be very similar to, as opposing counsel says, the department alleges, is a party in every case. Well, if the department is a party, then they also have to meet a burden of proof. So I'm not quite sure. The threshold issue is the self-employment, and in order to address the sideline issue, we must first deal with whether or not the claimant met her burden of proof, or whether or not she is not entitled to benefits because she is self-employed and does not have a sideline business exception.
Counsel, it's Justice Todd. May I interject? I think you make a very effective argument that this process complies with the statute. Our concern, and I'm speaking only for myself, is, and I think I'm echoing what Justice Baer was getting at, this approach where a claimant appeals at her peril seems to me, even if statutorily compliant, to be troubling as a matter of due process.
Well, due process is about notice and the opportunity to be heard. And in this case, the claimant did have notice and the opportunity to be heard. Throughout these proceedings, the issue was self-employment, and the claimant was on notice that she had to prove that she fit within the exception. If she did not meet her burden to show she fit within the exception, then she's just self-employed and would not be qualified for benefits in this case.
Well, I guess the problem I have with that is if a claimant meets a burden at the fact-finding level, what good is that if on appeal the facts can be totally revisited?
Well, if the board cannot revisit the facts, then Section 504 of the law is rendered meaningless. And parties have noticed that the board will visit the issues that are before it. And in this case, it was Section 402H.
Well, and that gets back to how I began my questioning. I think you make a persuasive case that your position is in compliance with the statute. My question is it constitutionally compliant?
I think it is, Your Honor. I think we provided notice and the opportunity to be heard, and those are the essential elements of due process.
All right, thank you.
Could I follow up, counsel, on the two justices' questions to you? The Mullane case from Supreme Court of the United States, 1950, says not just notice, but notice reasonably calculated to apprise the litigants. And I'm wondering what language in Section 504 was reasonably calculated to advise Ms. Quigley of this potential gotcha circumstance here.
Well, under Section 504, the statute specifically says the board shall have power to review any claim and may affirm, modify, or reverse the determination on the basis of the evidence previously submitted in the case or direct the taking of additional evidence. The language is plain that we review the claim and we can affirm, modify, or reverse the determination, and claimants are charged with knowledge of the statutes. So therefore, that put the claimant on notice. Not only that, Your Honor, from the beginning in the notice of determination, it sets forth the standard under Section 402(8) and the exception. It set forth the factual situation under which it was making decisions. Under that, the department continuously referred to both self-employment and the sideline business exception. In the notice of hearing, it specifically listed as the issue whether the claimant is whether the claimant is engaged in self-employment. That put the claimant on notice that the only issue was not what she appealed, which was the calculation. It was the issue of her self-employment. In the referee's decision, the referee listed the issue: is the claimant's income from self-employment deductible, and if so, to what extent? The claimant had noticed throughout these proceedings that the self-employment issue was the issue to be decided, and the board must address the threshold eligibility question under Section 402H of the law before it could get to the sideline business exception. And because the claimant failed to appear, she failed to present competent evidence to meet her burden of proof.
Justice Baer, can I ask you just one last question because I forgot before? Isn't your argument inconsistent with both Section 101, 107, and 10187 of the Code?
No, Your Honor.
About issues expressly raised or where parties provide prior permission for the board to go forward?
Actually, under board regulation 101.87, it says that the referee shall rule upon the issues expressly ruled upon by the department. In this case, the department ruled the claimant eligible because she fit within the sideline business exception, but it had also found that she was self-employed. Therefore, the claimant had noticed that this was an issue, Your Honor.
All right, thank you very much.
As far as notice, I mean, I'd like to move on to the Commonwealth Court's holding that line S applies to the UC process. Since the passage of Peak, where this court held that the board has de novo power of review over claims, the Commonwealth Court has repeatedly held that even though a party may not want to bring an issue before the board, if the party appeals and the issue is expressly ruled upon by the department and expressly ruled upon by the referee, that the department must rule on that issue. And the board's regulations found in 101.87 and 101.107 are merely a reflection of what is set forth in the statute by the General Assembly in Section 504 of the law. From the beginning, when a claim is filed by a claimant, the statute speaks in terms of validity and eligibility. There's no prosecution taking place. A claimant has the responsibility at every stage in the proceeding to show that she has made a valid claim and is entitled to benefits. Whether or not a claim is valid is set forth by the General Assembly throughout various sections of the UC statute. And in order to decide if a claimant is eligible or not, it's a fact-finding system. Parties submit evidence, and at the department level, there are no evidentiary boundaries in order for the department to make quick and efficient determinations to try to get claimants their benefits as quickly as possible. And therefore, they're limited in the information that they receive. When a party appeals to the referee level, the referee hears the case de novo, which means the referee hears the case from the beginning without any constraints. And he is allowed to make his own findings of fact and then affirm, modify, or reverse the referee based on those facts. And then if a party appeals from the referee's decision, the board is now the fact finder. The board cannot, as it is allowed to do under Section 504 of the law, affirm, modify, or reverse anything the referee did if it is stuck with the findings of the referee. Therefore, in order to ensure that only those claimants who the General Assembly has deemed entitled to benefits, the board must be allowed to review the department's determination and the referee's decisions and make its own factual findings and then come to its own conclusion to either affirm, modify, or reverse the referee. And in doing so, this court is not acting as a prosecutor. The Commonwealth Court even recognized this in the case of Press, that the department denying a claim is not an adversary adjudication. Therefore, if that is not an adversary adjudication, the board doing the same thing, making findings of facts and reaching a conclusion of law cannot be an adversary adjudication and is not a prosecution. And then I would just like to point out in this case as well that the Commonwealth Court spoke in terms of jurisdiction, whether the board had jurisdiction to do what it did. And I believe the Commonwealth Court erred because jurisdiction and power, the jurisdiction to hear something and the power to do something are not interchangeable. Jurisdiction is whether the board is competent to hear the decision before it. And then the power is whether or not the board has the ability to affect or order a certain result. And I will return to this, under the plain language of Section 504 of the law, the board followed the express statutory mandate of the General Assembly and made its own factual findings based on the competent evidence in the record and denied this claimant benefits. And then, I apologize. And then it's the curtailment. The Commonwealth Court's opinion is curtailing the board's fact-finding power. And I understand that it also must comport with due process, but the board gives parties due process by making sure that they are aware of what the issue is to be decided. And parties are given that in the facts as found by the department, in reference to the section of the law that they are that will be decided, and in board regulations which are parties are imputed with knowledge of. Therefore, the claimant
the counsel again, Justice Barrett, we've given you sort of a pass, and you've said about 5 times, 7 times.
Okay.
That the basis for the linchpin for your argument is the board's engaged in fact finding. But the question as to whether claimant is entitled to benefits is a conclusion of law. And it seems to me that if you actually want to develop facts to reach that conclusion, you do that by calling witnesses, examination, cross-examination. Perhaps, and I haven't thought about this, the board could have remanded this to the referee with directions to have the people testify and subject to cross-examination to arrive at this conclusion. But it seems to me to be a substantial leap of faith to say that the fact that she's not entitled to benefits by conclusion of law is purely a matter of fact that can be decided with none of the trappings of fact-finding under our system.
Well, actually, Your Honor, this court has held that we would not have been allowed to remand in this case because the claimant did not, A, request a remand, and B, assert a reason that could be considered good cause to warrant a remand. So that was not within the board's power in this case. We had to make a decision based on the pertinent and available records. And the only records in this case were a Schedule C that the claimant submitted and the claimant questionnaire. Out of those documents, the only competent evidence in the record was the claimant's admission that she owned and operated an independent business. That automatically meant that she is disqualified unless she could prove that she fit within the sideline business exception. We made our decision based on the pertinent available records and as allowed under board regulations, and the claimant simply did not meet her burden of proof, Your Honor.
Ms. Riley, I think you've ably stated the case for the Commonwealth, and unless you have anything else, we'd like to turn to the appellee. But it seems to me the essence of this issue is quite simply, can the board, consonant with due process, reverse relative to an uncontested matter? It's not much more complicated than that.
And I would just leave the court with eligibility should always be in dispute.
Thank you.
Thank you, Your Honors.
Hear from the appellee, please.
Good morning, Your Honors, and may it please the court. My name is Julia Simon Michelle from Philadelphia Legal Assistance, and today I represent the claimant appellee, Ms. Caitlin Quigley. The board's decision to sua sponte address sideline employment, despite claimant's narrow appeal of a computational issue, and then completely disqualify her from benefits, undermines the foundations of fairness the Pennsylvania Constitution guarantees all parties in administrative proceedings. This case, as Your Honors have recognized, calls upon the court to determine the proper role of the tribunal, the Unemployment Compensation Board of Review, whether it is, as the board argues, a super adjudicator charged with protecting the Unemployment Compensation Fund, or simply the final impartial step in Pennsylvania's administrative adjudication process for determining eligibility to vital benefits. Parties to unemployment compensation proceedings are entitled to a fair and impartial tribunal to review their claims and, importantly, contests of benefits. While the Board of Review does indeed have extensive fact-finding powers to ensure a complete record in adjudicating disputes, they do not and should not have the power to sua sponte raise dispositive legal issues on appeal that were not raised or contested by any party. The unemployment compensation law is a remedial statute, should be interpreted to broadly permit benefits. Instead, what the board is asking is that you give the board power to broadly deny benefits when no one ever contested those benefits. Now, Your Honors, the board brings up a few issues, namely that there's a threshold issue of eligibility at every level. And frankly, that's just not supported by the law or any aspect of the regulations that a claimant is responsible for establishing their eligibility at every level. In fact, in cases, for instance, involving a discharge, claimants have no burden. It is the employer's burden to establish that they are not eligible for benefits. And so there is no need or requirement that when eligibility has not been raised, that it somehow continues to be the claimant's burden at every step of the process. In fact, in this case, Your Honors, the claimant could not have even appealed her eligibility determination because she wasn't an aggrieved party of the determination that she was eligible. In fact, the only way that could have gone before the referee is if the department had come back and appealed that. But the department, as the investigative body in this case, determined that claimant was indeed eligible for benefits and then decided not to pursue it any further. That was their decision as the party in charge of determining baseline eligibility.
Counsel, it's Justice Donahue. Can I stop you there?
Yes.
Do you contest the fact that the role of the department at every level here is to adjudicate facts?
I do not contest that the role of the board is to adjudicate facts, Your Honor.
Okay, and let's talk about the steps in this process. The first place your client went was to a service center located in a mall or, a strip mall or wherever it was, and walked in and applied for benefits. Correct? I mean, that's the first stage. The employer didn't contest eligibility. And if your client had not appealed, that would have been the end of the story, correct? I mean, obviously, that's where we would be. You wouldn't be here if she had not appealed, correct?
Yes, and just to clarify, Your Honor, if I may, the claimant had lost a full-time job through no fault of her own, and the employer did not contest that. But the self-employment proceedings did not involve an employer.
I understand that. How would the separating employer know whether or not she met the requirements for an exception to self-employment?
So in this case,
because that's the predicate of this argument. These two people who at that initial level were adversaries agreed that she was eligible based upon the exception. At that point, how would the separating employer know the legal test or care to assert it? That's where this gets a little bit off kilter for me. I mean, obviously the system is set up so that those people at those service centers can handle tens of thousands of claims as they come in. Maybe under normal circumstances, that's not the case, but certainly within the last year, that's been the case. But after that level, given the General Assembly's direction to the department to protect the fund, what is the issue if an appeal is taken for the department to do precisely that? They're not adversarial. They're just saying your client has a burden of proof. That's the evidentiary standard. You come in, you make an appeal, and at that point, this notice of appeal said, we're going to ask you to establish your eligibility under the self-employment exception. Where else would that take place? Where else would the facts be gathered to adjudicate that claim?
So let me address that in a few points, Your Honor. First and foremost, the separating employer is not at issue here, so there is no role for them to play in this adjudication. The only role is between the department as a party and the claimant. And the department, even though it always makes the initial determination, also remains a silent party or active party, depending on its choosing, throughout the litigation. So I would note that often in self-employment cases, when the department finds someone ineligible and the claimant appeals, the department will send wage investigators to hearings to further contest and argue against the claimant's eligibility. But here, they did not, because they initially found her eligible and decided on their own not to continue pursuing the claim. As Justice Beyer mentioned earlier, this is very similar to, in essence, a party acquiescing a claim. That is what the department did in this situation. And instead, what happened was the board stepped in and placed itself in the shoes of the department to raise that issue, in essence, from the grave and adjudicate it on its own. Now, to address the question about the notice, Your Honor, the notice in this case is complicated because Section 402H involves three distinct legal issues. And the notice itself does not actually give claimant any idea about what is at issue in the hearing, because it is a blanket statement about self-employment. And I would note that if you look at Administrative Record Exhibit 5, the list of issues, that the board never puts anything next to 402H outside of whether a claimant is engaged in self-employment, even if that's not the issue. So claimants can actually never be on notice that the other aspects of 402H are at issue in a hearing based on how these notices are written to begin with. But the key here is that claimant filed a narrow appeal, and you can tell from all of the communications from claimant that she believed that the only issue was one of computation, and actually the referee agreed. The referee did the correct thing in this case, Your Honors. The referee specifically stated that the only issue before her was the deduction and whether a deduction applies and what it is, and found that there was still a deduction, but did not address the eligibility issue because no party had appealed it, and the claimant cannot have appealed that on her own. I recognize, as opposing counsel says, that there is some statutory authority here, but the key is, and what we're asking this court to do, is to construe the board's authority to be compliant with the Pennsylvania Constitution, to be compliant with due process and not run afoul of those due process guarantees. That
Could
while
I
they
jump
are
in,
a fact,
Could I jump in and ask you a question on that?
of course.
Suppose the court concluded that the statute and the regs as applied to your client was so problematic as to violate due process protections or due process guarantees. What would you suggest to us as the principal stopping point or the principled basis that we can articulate to give to afford future litigants and future claimants an understanding of what the rules of the road are, particularly in light of our longstanding principle that ignorance of the law is no excuse, and that pro se litigants are bound to understand the law, having presumably, at least as a legal fiction, having made the choice to represent themselves.
Your Honor, the way the court could do this is by holding that the board's powers do not permit it to sua sponte expand the scope of a party's appeal, that it can consider all issues before it that were appealed by a party. So if the employer appeals, if the department appeals, if the claimant appeals and raises the legal issue, which in this case didn't happen, then the board can do its fact-finding responsibility. It can ensure a complete record. It can make determination on credibility and on facts. But the core issue here is the ability of the board to put itself in place of a party and raise an issue that was not raised by any of the parties in what is, in essence, an adversarial proceeding.
Counsel, Justice Baer, can I ask you a follow-up to Justice Weck's thoughtful question? If the board prevails today, do you then, and does every lawyer representing a UC claimant have to go in to either the department, service center, or at least the referee and prove every element of a case, regardless of whether it's contested or not? Do we now bog down a system, as Justice Donahue said, that's had to hear tens of thousands or 100,000 cases because you have to go in and prove eligibility even though nobody's contesting it in this peculiar case?
I do believe that it is more of an administrative burden, Your Honor, and on the system to require parties to continue to litigate issues that are no longer in dispute. I will note, however, that that's the current burden that we face. That's one of the reasons we're before this court here today, asking the court to construe the powers of the board to be consistent with due process. Right now, I can tell you as an attorney myself, the first time I walked into a hearing where the claimant had been found ineligible based on able and available one section, but eligible based on her voluntary quit. She appealed the able and available issue. We showed up at a hearing. The referee, I was prepared on the able and available issue, and the referee started questioning my client about her eligibility on the voluntary quit. And I said, Your Honor, the employer didn't appeal that. That issue settled. It's final. And the referee goes, well, under our regulations, I can consider everything. And I do believe that that is a problem. with due process, which is why we're here today. And also, Your Honor, there's this aspect of chilling appeals that I really worry about, especially when we're talking about the vital nature of unemployment benefits, especially as you can see today, that a claimant believes they may have expanded eligibility, there may be a computational issue, they may want to still contest, let's say, the underlying eligibility of an overpayment. But by appealing, based on the board's use of its powers, they continue to put themselves at risk of losing benefits entirely, in essence, having the rug pulled out from under them. And so we also worry because sometimes we actually have to advise clients based on the current practice of the board that they could harm themselves if they want to continue to fight for their eligibility. And that is problematic with due process, Your Honor.
Thank you. I
Counsel,
think,
Chief, it's Justice Donahue. Can I just follow up
Oh,
on,
sure.
on this for,
Sure.
just so I understand? The example that you gave of the hearing that you attended, I guess what I'm drawing from that is that it's your position that separating an employer and the claimant can agree on how funds are to be dispersed from the unemployment compensation fund.
No, Your Honor.
Well, how is that not the case? I mean, if you, if the referee and the board and in every level, they're bound by an agreement of the parties as to how funds from the fund are to be dispersed, isn't that exactly what you're arguing? Two private individuals can determine how funds will be dispensed from the fund.
Well, Your Honor, it was not an agreement and would not be an agreement between two individuals because there is a fact-finding process first at the service center level, and then the employer has the ability to appeal. And actually, just to be clear, Your Honor, there was an eligibility issue still there in that case. That claimant had to prove the able and available. So it was not as if there was an agreement between the parties where that claimant was kind of scot-free to move forward and collect benefits. There did remain an issue, but this happens all the time, Your Honors, where an employer, let's say a notice of determination is issued finding a claimant eligible, and no one appeals it. That's how the system works. It's an adversarial system in that manner. And so that's consistent, right, with due process and how we treat adversarial proceedings. The board's power of fact-finding only come into play to ensure a complete record and review the issues when those issues are actually before it. And that's why we have asked the court here today to evaluate the board's powers in light of these due process concerns. And we would therefore ask the court to affirm the opinion and decision of the Commonwealth Court in this matter.
Thank you.
Thank you. Thanks to both of you. We'll conclude argument in this case. Take about a 5-minute break and begin an argument in the next case.
The next argument is in the matter of Commonwealth of Pennsylvania versus David Pacheco. Representing Mr. Pacheco is Mr. Brooks T. Thompson. Representing Commonwealth is Mr. Robert M. Fallon.
Good morning. In this criminal case, the court issued an order under subchapter E of the Pennsylvania wiretap statute, which authorized the police to collect appellant's real-time cell site location information for a period of 108 days. The issues are whether the collection of such data constituted a search under the Fourth Amendment, and whether issuance of a court order, as opposed to a search warrant, violated appellant's Fourth Amendment right to be free from unreasonable searches and seizures, as well as his counterpart right under Article 1, Section 8 of the Pennsylvania Constitution. Thompson.
Mr. Chief Justice, and may it please the court. Detectives initiated electronic signals to Mr. Pacheco's cell phone. Those signals reached into Mr. Pacheco's pocket and forced the phone to acquire its own location and in turn send that information ultimately back to law enforcement. And they did that for 108 days. So the Superior Court was correct when it concluded that such an intrusion on Mr. Pacheco's privacy was a search under the rationale of Carpenter and that thus a warrant was required. But the Superior Court was wrong when it held that the subchapter E orders are the functional equivalent of a warrant. They are not, because they fail to effectuate the very purpose of a warrant, and that is to prevent against general searches. These orders, by their very terms, granted law enforcement unfettered discretion to monitor Mr. Pacheco's location around the clock without geographic limitations, including into private residences, at places and in times, the majority for which there was not even an attempt to establish probable cause. In fact, there was not even a finding that Mr. Pacheco was likely to be engaged in criminal activity for each of the 60-day intervals for which the authorization was granted. And that's because the issuing authority in this case was not presented with an application for a warrant, but an order under subchapter E. That statute allows law enforcement to monitor an individual's location upon a showing of probable cause that doing so will lead to information which is relevant to a criminal investigation, ongoing criminal investigation. That's a far cry from the probable cause to get a warrant, which is probable cause that evidence or contraband will be located in the particular place and at the particular time. The universe of what is relevant to an investigation is far greater than evidence of a crime, and it's often a matter within the discretion of law enforcement. So no, Your Honors, the subchapter E orders were not the functional equivalent of a warrant, and therefore the Superior Court should be reversed. And with that, I'd be grateful to answer any questions that the court might have.
Thank you.
Counsel, Justice Baer, you quote only from B1 of 5773 B1, small 1 through small 5. And the statute says an order issued under this section shall specify, and then has the 5 criteria. So just as an example, the second criteria is the identity if known of the person to whom is listed on a targeted telephone and the person using the targeted telephone. So just with that as an example, if we aggregate 1 through 5 of the Pennsylvania Wiretap Act, it's a very different statute than the Federal Stored Communication Act considered in Carpenter. What specifically is lacking, looking not just at 1I, but 1 through 5, that would be in a warrant?
Well, Your Honor, specifically what's lacking is the individualized suspicion that the particular individual is going to be engaged in criminal activity at the time of the search, and the nexus between the Pacheco's location and anything that there's an attempt to establish probable cause for. So the fundamental problem is that this order doesn't require the particularity as to any finding of criminal activity. And really, the overarching problem is that section, I would submit, Your Honor, that I quoted, which is the probable cause finding. Everything flows from there. So for instance, in this case, law enforcement identify, by reference to the statute, what crimes that they're limited to. And the reason that this is allowed because the statute doesn't link anything to criminal activity or evidence of a crime, just in an ongoing investigation. And that's why it's often disconnected, and in this case was disconnected from any showing of probable cause as to Pacheco's criminal activity.
Counsel, it's Justice Todd. I understand very clearly your probable cause argument, but just before you answered Justice Baer's question, I thought I heard you say you had a problem with this statute because it allows unfettered access by law enforcement. Now, that is not the case here. You do have an order entered by a judicial officer.
Yes, Justice Todd, that's correct. You have an order entered by a judicial officer that allows police to search the location for a particular phone. However, after that, the time to search, where to search, the locations that Pacheco goes to, that's all left to the discretion of law enforcement. In other words, the order is granted for 60 days at a time, and everything else is up to the police as to when to monitor Pacheco's location. So when Pacheco, in this case, he operated a lawful tow business, there's nothing in the order to attempt to limit the scope of law enforcement search to anything for which there was a finding of probable cause. There's not even an attempt. It allows law enforcement to track him at all hours of the day.
But it is, I agree with you, but it is in fact limited by the terms of the court order that the judge signs.
In terms of that, yes, Justice Todd. But I would submit that that's not very limited. You see, because the scope of the search, as this court and courts in the Third Circuit and the Supreme Court have held, the scope of a search is limited by the judge's finding of probable cause and what the judge found probable cause for. So when you have an order here that says information relevant to a crime, including but not limited to, and then it lists several crimes, it's an open warrant.
Counsel, this is Justice Doherty. I have a question. When you look at the statute 5773 and you look at the language of the probable cause for an ongoing criminal investigation, I agree with you that that appears to have watered down the concept of probable cause. But when you assume the subparts of 5773, it's almost the equivalent of a warrant. But the question that I have for you, and as an aside, the concept to think that the officers can use these cell site location information for your every move is somewhat chilling. But in this particular incident, there were affidavits. There was, what, a 39-page warrant. It's signed by a judicial official, and they're looking for his exact location to determine whether he was in Mexico, Norristown, or the Bronx. So why would that not fall within the specific requirements of a warrant that his location is the exact issue at issue?
I understand, Justice Doherty. Well, so that would in part be remedied if there were a requirement that police show probable cause that Pacheco would be actually engaged in criminal activity during that period. The statute doesn't require that, and that wasn't the case here. That wasn't found here, and it wasn't even shown for that period. So the understanding that police are going to have a little bit of additional discretion when they're searching a person's cell site location information, because they can't necessarily predict where that individual is going to go. There needs to be some mechanism, some limit on that. So for instance, to say when Pacheco's clearly just going about his business in Norristown, there's nothing here that requires police to terminate and stop the location monitoring at that time. They're able to continuously do that regardless of whether there's any reason to believe. In fact, they could know that he's not engaged in any criminal activity at that time, and the order still permits them to monitor him. And that's the problem with the order.
Counsel, question. Are you, in fact, making a facial challenge to the statutes similar to the Amici as well as the Commonwealth?
No, Your Honor. What we're asking this court to do is something that the courts routinely do. We're asking this court to determine that a warrant was required for this search, and that because police didn't have a warrant, the evidence should be suppressed. It is within the scope and the role of the judiciary to determine whether an individual search complies with the requirements of the Fourth Amendment in Article 1, Section 8 of the Pennsylvania Constitution. And I think that the Carpenter Court decision tells us that, because in Carpenter, the court found that the Stored Communications Act was not a permissible mechanism for police to obtain historical CSLI, but the Carpenter Court didn't pass on the constitutionality of the statute. And they could have, but they didn't even discuss it in the majority opinion. It's not that it wasn't raised in the Carpenter decision. In fact, it was in the Sixth Circuit Court of Appeals opinion, but it wasn't discussed by the Carpenter Court, because that tells us that, like a warrant, analysis of a warrant, it is the role of the judiciary to determine whether the Fourth Amendment requirements were met. And in addition, Justice Dougherty, I would submit that the Commonwealth's argument that, on the one hand, this is the functional equivalent of a warrant, it provides the same protections of a warrant. They argue that on the one hand. Then on the other hand, they say, well, because this was an order and it was entered in compliance with the Wiretap Act, the defendant bears this high burden of overcoming the constitutionality of the statute. Well, I would submit, Your Honor, that that's inconsistent with the premise of the argument that this is the functional equivalent of a warrant. Because in order to provide the same rights under the Fourth Amendment in Article 1, Section 8 to the defendant, there must necessarily be the same availability of judicial remedies to vindicate those rights. And the Commonwealth's argument tells us that there's not.
Counsel, do I understand you to say that any order under the Wiretap Act would be unconstitutional based upon your argument? And if so, is that not a facial attack? I'm confused as to what you're trying to tell us.
No, Justice Dougherty. I'm not trying to suggest that any order under the Wiretap Act would be a violation of the Constitution. What I'm suggesting to the court is that, so there are certain orders that require significantly more, like an order for an oral interception. They require significantly more safeguards than what even a warrant requires. So in those circumstances, I think that there could be an argument, and as the United States Supreme Court held in Dahlia, those types of orders are the functional equivalent of a warrant. But in this case, it's not the same as the type of order that was considered by the court in Dahlia. So, for that reason, it is possible that certain orders could be the functional equivalent of a warrant, but not these orders.
Counselor, what difference does that make? Is there precedent that would guide us if we in fact decided that that is in fact what happened here? And are there provisions within our Wiretap Act that are more applicable to the situation that we have here if the phone is viewed as a GPS tracker?
Yes, Justice Donahue. So in this case, the the cell site location information was acquired by the phone activating its location subsystem, which involved the phone acquiring its GPS location. So it was essentially identical to GPS tracking, the same precision. And what we argued in the lower court was, and we argue here, that under the Supreme Court's case in Caro and the concurring justices, the rationale of the concurring justices in Jones, all of those apply to this case. And it's interesting because Pennsylvania's Wiretap Act has a statute that relates to GPS tracking. They call them mobile tracking devices. And that statute specifically requires a finding of criminal activity, and it also requires that the information to be searched for be evidence of that criminal activity or be related to that specific criminal activity. Moreover, in order to track a GPS that has been withdrawn from the public and into a private residence, the GPS statute requires a showing of probable cause of ongoing criminal activity within that private residence. These orders under Subchapter E require none of that, despite the fact that they're authorizing essentially the same thing.
Okay, thank you.
Counsel, Justice Baird, questions. The first is, it seems to me you're arguing very, very well that subsection E I guess that's what it is. It's 5773B. That it's not the equivalent. Its criteria, especially in terms of probable cause, is not the criteria of a warrant. Is it possible that that's true? That the law surrounding warrants and the law surrounding wiretaps are discrete and not the functional equivalent of one another. But notwithstanding in this case, because of the 30-page affidavits that were submitted by the police before they got the warrant and the information that was provided, that this warrant is that this, in this case, the Fourth Amendment is not violated by the wiretap orders because of the amount of information and the particularity of that information that was supplied.
Well, Justice Baer, the first thing I would note would be that I don't think that the affidavit of probable cause in this case was very particularized, particularly with that 60-day window for which there was the authorization was given. But more importantly, Justice Baer, this court told us in Commonwealth versus Chandler that the determination of whether probable cause exists for a warrant is to be made by the issuing authority. It's not something that's to be made after the fact. And here, the only question before the judge that issued these orders, the only question before that judge was, does this order, application for an order, does it satisfy the requirements of this act? That was the only thing that was before the judge. There's no reason to believe that the judge found anything else because he wasn't asked to find anything else. And specifically, the Superior Court notes in their second opinion, in their current opinion, that the order specifically found that the cell phone tracking would lead to the apprehension and arrest of Mr. Pacheco. It does not do that, Justice Baer. The order is attached to the brief as Appendix G, and there's no such language in there. And in fact, the Superior Court even noted that in their first opinion. In a footnote, they indicated that the judge here found nothing greater than the standard that was required under Subchapter E. And that makes sense, because why would the judge find anything greater than he was asked to find?
Thank you. Good answer.
Okay, thank you. We're going to turn to the Commonwealth argument from Mr. Fallon.
My name is, may it please the court, my name is Bob Fallon from the Montgomery County DA's office. The orders here for real-time cell site location information under 5773 were the functional equivalents of warrants for three main reasons. First, the plain language of the statute includes all the necessary elements for a warrant. Two, this court's case law and the legislative history of Section 5773 show that the probable cause in it is the well-known constitutional standard of probable cause, not some new, novel, modified statutory approach to probable cause that I, at least, have never seen used.
Counsel,
And third,
Counsel, let me stop you there because that requires scrutiny. The statutory requirement for probable cause in the Wiretap Act context is quite different from the search warrant context. It says probable cause to believe that information relevant to an ongoing criminal investigation will be obtained. Are you aware of any cases that permit a search warrant to issue based on probable cause that it'll be relevant to an ongoing investigation? And if you have such cases, A, I'd like to know what they are, and B, I'd like to know why law enforcement would ever, under these circumstances, apply for a search warrant when they could just use the wiretap order.
well, Your Honor, the law enforcement has to use the wiretap statute currently. So when they do want CLSI, they have to use the Wiretap Act. And the standard used in the statute is no different really than the established definition for probable cause in the context of searching locations for evidence. That is a fair probability that evidence of a crime will be found in a given place at a given time. that there's really, I don't see any functional difference between those two, especially when you read that definition in the context of the other requirements of the statute. The statute not only says the probable cause, which you recounted correctly, but it also says the statute says that the affiant must identify the place to be searched, which is the targeted phone, and the items to be seized, which is the CLSI. The statute also requires the identification of the phone's possessor, if known, which it was here. We knew this was this defendant. We put him in by name in the affidavit, and the specific crime the sought after information will relate to. So that, read in context of the entire statute, that is probable cause, and judges know what probable cause is. I mean, that is a major signal to any jurist who has sat in the criminal court that this is a constitutional level inquiry. I can't imagine any judge seeing probable cause in a statute with all of those requirements and thinking to himself or herself, well, gee, that must be some sort of new novel approach to probable cause that I haven't seen yet, but you know what? I'm not going to apply the constitutional level of inquiry. That is really, it's unimaginable.
It's probable cause to believe that information relevant to an ongoing criminal investigation, that's a very, very wide door to drive a Mack truck through. I mean, is there anything in the course of a law enforcement investigation, anything reasonably that could not be construed as relevant to an ongoing investigation?
Well, in the abstract, there's always some sort of fantastic outlier case, and that's what the defendant posits in his brief, because he wants to avoid the facts of this case. The facts of this case, as was mentioned earlier by, I believe, Justice Doherty, was that the law enforcement was looking for one thing and one thing only: the location of the phone as it related to whether he was trafficking drugs from Norristown to Mexico, back to Norristown to the Bronx. That is very specific information, which, if read in the context of the order and the warrant, and this court's case law requires this court to consider them both together, that's very specific information. That is not some sort of fishing trip that's going to allow them to rummage about, you know, as Mr. Brooks would like you to believe. This is very specific, discrete information relevant to specified criminal activity, drug trafficking along a specific route.
And so, Justice Baer, I'm going to follow up on Justice Fleck. I thought you said, it caught my attention at the beginning of your answer to his query, that police have to use the Wiretap Act under these facts, that they could not go get a warrant. Is that your position?
That's my understanding, Your Honor.
Why is that?
Because
we find that the Wiretap Act is not the functional equivalent of the general law surrounding warrants, and you have to get a warrant. Are you telling me all these investigations must fail because police are caught in the catch-22 of us saying you need a warrant, and there's some law out there that you're aware of that I'm not aware of that says you can't get a warrant, you have to use the Wiretap Act?
I understand what Your Honor is saying now. Certainly, if this court invalidates the statute, then there would be the option of going through for a warrant. My understanding is that until the court invalidates the statute, this is the route the General Assembly has laid out for law enforcement, and we must follow it. But of course, yeah, if the court invalidates it, then there is a warrant process available. But the warrant process, as this court has noted in the past, is basically, if used for electronic surveillance, is going to defeat the entire purpose of electronic surveillance. For example, the current warrant rules require law enforcement to serve a copy of the warrant on the person affected. And if this court rules the way Mr. Thompson wants it to rule, that person affected will be Mr. Pacheco. And as he's getting ready to traffic heroin, he will be served with a copy of the warrant saying, law enforcement's going to be pinging your phone. He will also, that warrant will have to be executed within 3 days. So it will last only 3 days, which is not enough time in these types of investigations. Somebody may not take this type of trafficking activity within 72 hours of serving the warrant on the defendant. There needs to be an extended time frame to be able to encompass this type of trafficking activity. So the warrant rules as currently constructed would render this type of investigative tool, which is absolutely critical, especially in today's day and age, absolutely defunct. It would not work.
Counsel, this is Justice Doherty. Do I understand you to say that the warrant requirements would restrict law enforcement, but the Wiretap Act permits unbridled discretion, which is why we should permit unbridled discretion in the pursuit of criminal justice, despite our concern about citizen privacy?
Wow, I better be careful with that question. No, that's not what I'm saying. I'm saying the Wiretap Act is specifically designed to accommodate this type of investigative technique. It was amended in 2012, completely revamped, overhauled. I was involved in that process. I was part of the law enforcement stakeholders, worked with the ACLU, worked with the Criminal Defense Bar, worked with the Judiciary Committee, because everyone knew that in this day and age, when our society has fundamentally changed from the last time it was amended, which was 1988, that massive changes needed to be done to govern this type of investigative tool. And the Wiretap Act provides, I think, more protection for defendants. It gives more protections to the defendant. Specifically, there's a common pleas judge making this initial determination, not a magistrate judge. And it's specifically designed to adapt law enforcement to this new day and age. Pennsylvania has been ahead of the curve on this. The old warrant rules simply don't accommodate this. So the wiretap, I think it's unfair to say it gives unfettered discretion to the police. It keeps them monitored.
Mr. I apologize. I didn't mean to cut you off, but you raised an interesting issue. I need you to help me understand your argument. Let me clarify. I was a former prosecutor. I was a former defense attorney. I understand both sides of the spectrum here. The concern that I have is you're asking us to make a decision which will have a practical implication in the courtroom. So the concern that I have is we know that when as a prosecutor, you're obtaining a warrant, we're required to make sure that it's particular and specific, and we even have a time restriction as when the police are able to go obtain information. Okay, but in a wiretap warrant, there is, quote unquote, wiretap permitting an ongoing investigation, as Justice Sweck was describing. How is it that, unlike a warrant, this ongoing investigation does not equal unbridled discretion for law enforcement continuing to track someone's every movement? Do you understand my question?
I believe so. And I guess that goes to the 60-day length of the monitoring, which the U.S. Supreme Court has not weighed into that issue yet. And that is just one of the issues that is rapidly developing, and it's the Supreme Court has not ruled on that, the U.S. Supreme Court, and neither has this court. And that's really not, as far as I understand it, the issue here. The issue is whether this statute equates to probable cause as required by the Constitution. And I think you have to look at this case, actually look at the facts, look at the affidavit. This affidavit, Mr. Brooks suggested this affidavit wasn't particularly strong. This affidavit was 39 pages long. Mm-hmm. It was based on the personal observations of the affiant, other law enforcement. It was based on information from other law enforcement agencies, from confidential and reliable informants. It was based on other electronic and physical surveillance. It identified defendant as a source for heroin, that he was potentially trafficking this out of country from Norristown up to the Bronx. And the specific crimes that he was suspected of committing were identified. So unless this court thinks that a 3-day limitation, which is essentially what would happen under the warrant rules, is for some reason the only fair time limit, I don't think 60 days is unreasonable. And it doesn't have to be 60 days. That's within the discretion of the trial judge. Trial judge could say, yeah, you know what, based on what I read here, you have enough for 3 days. Or he or she could say 30 days. But at the absolute most, the judge can only say 60 days, at which point the Commonwealth has to come back and justify more time. So this is not unfettered. This is supervised, and it's supervised at a level that a warrant would not be. And in another protection, the wiretap in general, some orders have to go to a superior court judge.
Okay,
So,
Mr. Fallon, can you educate us, since you were part of this? Your order read, the order shall be without geographical limitation, including private areas, as long as the results of the disclosure of the mobile communication tracking. The question I have, is it scientifically available to obtain the pings only if this individual's phone pinged in Mexico, Norristown, and the Bronx, such that you would be notified should the, if you're trying to locate the purpose of the cell phone information is his location to determine whether he's tracking. You're not trying to obtain his text.
Right.
So why could you not obtain a very specific and particularized wiretap act warrant, since it's similar to our search warrant, saying we are looking for Mr. Pacheco's pings in Mexico, Norristown, and or the Bronx? Why could that not have been possible? And then there'd be no issue before this court. I think the problem with this case is that you're tracking his every movement and whether he's in bed or in the bathroom.
well, Your Honor, that actually is not true. The pings in this case were, when law enforcement gets a list of the pings and are notified of the pings, there's a degree of uncertainty. That degree, and that is the uncertainty as to the location of the phone. That is typically between 500 and 1,000 meters. In this case, it was much better than that. It was 30 meters, and that's in the suppression hearing notes. 30 meters was the degree of uncertainty. So there was no way, if he's in his row home in Norristown, that we're going to be able to track him going from his bedroom to the bathroom or from room to room. That's just not feasible, because you'd have to have the phone company acting as the mediator in real time, releasing only certain pings in real time to law enforcement. So unless there's some sort of, maybe the Stored Communications Act could be amended to require the phone companies to sort out through all these real-time pings, maybe that's a possibility, but that is not how it works, and I don't think it's practical. I don't think it works. And I think right now, at least, and especially in this case, with the degree of uncertainty being 30 meters, which is a significant amount of, about 90 feet, especially when you're talking about, Norristown and tight quarters and row homes and businesses. I don't think that is, you're not identifying it in his pocket, or now it's next to his bedside table. That's what Mr. Brooks kind of suggested, and that's just not what happened here. The record refutes that. So I just don't.
You answered it very well. Thank you.
Thank you.
It's Justice Donahue. The geographic limitation that you described does in fact get you, though, to a point when you would know that the defendant was in his residence. Is that correct?
Not necessarily. If it's a row home in Norristown and it's a 90-meter degree of uncertainty, that does not necessarily mean that you can identify which row home he is in. He might be next door. He might be outside so it's not. No, that's not necessarily true.
Okay, maybe you could just explain something of a technology / jurisdictional question that your argument has raised in my mind. This Montgomery County court issued an order to ping / track this defendant in Mexico.
Yeah, well, it allowed us to ping the phone. It didn't really deal with the location of the phone.
But I guess that's what I'm struggling with here. I thought that what we were dealing with in the context of the order that was issued here, that we were tracking his location in Pennsylvania. That's not the case.
Well, it's partly the case, but also out of state.
And how does that happen? I mean, how does the jurisdictional limitation of the court extend that far?
Because we're getting the information from the phone company, which is within jurisdiction, Your Honor. That's where the information is actually collected, and that's where we obtain it.
But the defendant was the object of the order.
The targeted phone was the object of the order.
Well, any phone that the defendant had was the target of the order.
Well, there were certain phone numbers that we had connected to defendant that were the subject of the order. So he and his person wasn't the subject, nor was any phone in his possession. It was the numbers that we could build a case that he had that linked him with probable cause to that number.
And I assume that your answer to my question to your opposing counsel regarding the analogy between phone as GPS and this case is that it's not like a GPS because of the limitations on the ability to pinpoint location.
Right. The mobile tracking device section of the Wiretap Act, 5761, a mobile tracking device is much more accurate. You can like your Honor said, you can track it, with some precision. But just on that note, I think it's interesting that the provision 5761 for mobile tracking devices uses the same type of language as does 5773, and that is the use of the tracking device. It must be probable cause that it will yield information relevant to the investigation of criminal activity. So that section uses very similar language. And so I think that was amended after Jones in 2012 to reflect the constitutional level now required under Jones for mobile tracking devices. And, if one of my points that I wanted to make was that there's no question the General Assembly intended this to be a constitutional level of probable cause. This court back in 1988 in Commonwealth versus Malili held that pen registers are, unlike the federal law at the time, under Article 1, Section 8 of the Pennsylvania Constitution, pen registers required probable cause to obtain. And so the law was then changed in 1988 to reflect that, and that's what resulted in 5773. Fast forward to 2012, the Wiretap Act is amended to include CLSI, which is identified in the Wiretap Act as mobile communications tracking information. That's defined in 5702. The legislature had a decision to make. Where do you put that mobile tracking communication information? Do you put it in, let's say, the call detail section, which is just one moment. That is 5743 is call detail records. And in the call detail record standard is exactly the same language to a T used in Carpenter. It's specific and articulable facts that provide reasonable grounds, and the entire phrase is the same as Carpenter. That's called detail records. They could have put it there, and there were discussions where to put it. And the legislature put it instead in the pen register section, which was established to require a probable cause. They put it in 5773 for the reason that they thought that it needed it and that eventually a court would say it was a constitutional issue. So there's no question that the General Assembly intended this to be probable cause, meaning the normal sense of probable cause that's applied almost every day in a criminal court. Yes, certainly.
With regard to the Constitution, counsel, just so I'm clear on the Commonwealth's position, what is the place to be searched that is particularly described by this order that you say substitutes for a warrant?
Your Honor, the place to be searched is the phone that is identified by its number in the application. And the items to be seized is the CLSI. So it's not granting, we can't seize the phone and search everything. We can't listen in. We can't do anything with the phone except that number, which is the place to be searched, and the CLSI. That's all we can seize under this order.
Counsel, it's Justice Todd. As a district attorney, could you use this Wiretap Act and try to get an order from a judge to allow you to do this exact same thing in order to try to identify the movement of the suspect, but by doing it with respect to someone he's affiliated with, not himself? In other words, could you get an order to track his girlfriend's phone or his mother's phone in order to try to identify him? Because if that's the case, then the whole probable cause assessment, to me, just goes out the window.
I would imagine there would be a case that you could target, I think, at most, a conspirator. I'm not
talking about anyone with any level of suspicion or, alleged guilt. I'm talking about someone who is known to have a relationship with the suspect.
I don't think so, Your Honor. And I'm not familiar with us using it that way.
Counsel, Justice Baer, just one last time. The aspect of your argument that really took me up short was that the appellant here, defendant here, says you made a mistake because you should have used a warrant. And the courts, at least in my prep, tried to compare the wiretap Act with the requirements of a warrant. And you're saying, if I understand it, and I want to make sure before you sit down, that you would never use a warrant here. This is an inappropriate situation for a warrant. The whole purpose of this statute is to deal with this scenario. Now, is that correct?
That's correct, Your Honor, because if let's say we did use a warrant for this electronic surveillance here, Mr. Thompson would go at the suppression hearing and he'd say, this is a violation of the Wiretap Act. They got a warrant from a magistrate judge. Under the Wiretap Act, only a common pleas judge can issue this type of order. So we would be out of luck and he would be right. We would be violating the Wiretap Act if we used a warrant in this situation. Now that changes, of course, if this court invalidates the statute. That's a completely different scenario. But as of now, if we use the warrant procedures when there is a wiretap provision, the defendants are going to flip it on us and say we are not complying with the Wiretap Act, and as such, they're entitled to relief.
Thanks, Chief.
That's pretty much where we began, I think. Are there any other questions? If not, we're going to wrap up the argument. Hearing none, we thank both of you, and we'll take a brief 5-minute break and call the next case.
Thank you, Your Honors.
The next argument is Commonwealth of Pennsylvania versus Alkeon Dunkins. Representing Mr. Dunkins is Mr. Michael J. Diamondstein. Representing the Commonwealth is Ms. Catherine R. Kernes.
Good morning. An armed robbery occurred in a college dormitory. Without obtaining a warrant, the police acquired connection data from the college's wireless computer network to determine that appellant's cell phone was in the dorm at the time of the incident. They also used such information to obtain incriminating evidence concerning appellant's movements between college buildings shortly before and after the robbery. Appellant requested that the trial court suppress the evidence on the basis that its acquisition by police constituted a warrantless search for Fourth Amendment purposes. His request was denied, and he was ultimately convicted in connection with the robbery. The court is presently asked to determine whether suppression should have been granted in light of a recent United States Supreme Court decision involving cell tower connection data. You may begin your argument.
Thank you. May it please the court, Mr. Chief Justice, Justices, Ms. Kernes, good morning. The Fourth Amendment to the United States Constitution provides for the rights of its people to be secured from unreasonable searches and seizures. As Justice Doherty so aptly put it in a number of questions in the previous argument, the thought of giving law enforcement unbridled discretion to use our cell phones and devices against us to track our every movement is chilling. Recognizing that, the United States Supreme Court took a number of, small steps, first in Jones and then in Carpenter, to recognize that all of us have a reasonable expectation of privacy in our movements. Alkeon Dunkins was historically geo-tracked by law enforcement. With the flip of a switch, they were able to track every one of his movements.
But this is very different, counsel. This one's very different, isn't it? This is a tower dump, isn't it?
Respectfully, Justice Weck, I disagree. And I think part of the problem is that, at least for me, not really technologically proficient. We use that term tower dump, but the technology is different. What I suggest to the court is that this is a Wi-Fi search. And the reason why I suggest there's a difference, if the court takes a look at the Carpenter opinion, and especially the dissent of Justice Kennedy. Now, while obviously it's two different prosecutors, right? So we have the Commonwealth of Pennsylvania here, and we had, the U.S. Attorney's Office, Department of Justice in the Carpenter case. The argument in Carpenter with respect to the CSLI that the United States was making was, well, this isn't GPS. And what Justice Kennedy said in his dissent was, he went into some of the different technological mannerisms of a CSLI search. What's in that opinion is that CSLI does not give you specific location. And it's actually, as the prosecutor in the Pacheco case argued as well. In Pacheco, they're talking about 90 feet. In Carpenter, on a tower dump, what you're talking about is every single person who is within somewhere between a quarter mile and 4 miles, or if you're in the rural areas, maybe up to 20 miles. What we have here, using the technology of a Wi-Fi search, in this particular case, they could put individuals in a specific dorm room within feet. So that's why I respectfully suggest that while it's easy for the government, in this case, the Commonwealth, to couch it as a tower dump, it is not a tower dump because of the specific nature of the information given to law enforcement. Unlike Pacheco, where they can say, well, he was in Norristown, maybe in this row home, maybe in that row home. Unlike Carpenter, where they would be able to say, well, he's somewhere within this cone. In this particular case, this technology was good enough to put Mr. Dunkins on a specific floor, in a specific room, and then watched him specifically go.
But isn't the difference, there's a brief follow-up to my question, counsel. Isn't the difference that in those cases, they were looking for Carpenter, they were looking for Pacheco. In your case, they're just looking at everybody. It's a dump. It's like, isn't it akin to that security camera above the entrance to the dorm that has a date and time stamp for every person coming in and out? Everybody, not just Dunkins, anybody.
Well,
What's
you
the
know,
difference?
that's a very apt question, if I may, Your Honor. And so I have to break it down. First is the difference is cameras, Carpenter specifically excludes. And I can't tell the court the rationale why Carpenter did it because I don't recall it being in the holding. But I respectfully suggest to the court is that the purpose of a camera is for a security function, right? So the purpose of that camera, when you put it in the hallway or you put it, in a lobby or outside on a tree, the purpose of that camera is for a security function. And every individual who walks by that area and sees that camera knows there's a camera watching me. The difference is my cell phone is not supposed to be for law enforcement tracking of me. So I respectfully suggest to the court that that's the reason why there's a difference between camera and cell phone. Especially because Carpenter and Jones says that that these cell phones are such an inextricable part of our lives. So I respectfully suggest to the court that's the difference between the camera analogy. With respect to the second part of your question, again, with respect to the dump, and it doesn't go directly to what was in Pacheco, but it dovetails on that. The issue there was whether or not related to the wiretap is the same as a particular search by a warrant. That's God bless you. That's the same issue that we have here. Is that what the government did here was it was the same thing as a dragnet. It's the same thing as a general search or like what they did was they used the wide shotgun effect instead of the scalpel effect. At no point during my argument or in our brief would we ever suggest that the government wasn't entitled to this information. Our point is that the government is entitled to this information after providing probable cause of a particular search narrowly tailored to the criminal interest. And so what the government did in this case by just saying, give us everybody who was in that dorm, that is a general search. And while I don't begin to raise the constitutional rights of other individuals, that shotgun type search that the government did, that general search, procured information on two females that at 2 o'clock in the morning were in somebody else's dorm. And so our position is when the government wants this tracking information, when the government wants to use our cell phone devices as a GPS tracker, they must do so with particularity supported by probable cause. In this particular case, the government could have accomplished the same exact result, but done it constitutionally by making a warrant, asking for any cell phones that pinged off the closest antenna to that dorm room. And by doing so, it would have protected the rights of Mr. Dunkins to have a neutral, detached magistrate review the probable cause. It also would have protected all of the other individuals in that dorm room where the government now knows who was there and who wasn't there. So that's the best that I can do to answer that question, Justice Weck.
Counsel, it's Justice Baer. I've been listening patiently. I think this case can be written narrowly, and none of your issues are we never even get to any of your issues. What do you do with the Moravian College handbook, which was obviously written by lawyers? Users cannot and should not have any expectation of privacy with regard to any data stored on computers connecting to the institution's network. How is that not just as clear and conspicuous a acceptance of terms by your client as can be ending the case?
So for a number of factual reasons. First, there is nothing on this record to indicate that my client signed that. So, in fact, the record is clear. They couldn't produce that document. So the first thing I would say is if you're going to have a waiver, it needs to be a knowing, intelligent, and voluntary waiver. And there's nothing.
Yeah, but you get, counsel, let me interrupt you. You get a major university. They don't have everybody sign the handbook. They pass the handbook out. They may have 25,000 freshman students.
Okay.
So does the record indicate that your client's a Moravian student?
Yes.
So
absolutely.
This is the Moravian handbook.
Right. And it's not on the record, but the court, if the court wants or could go online, the Moravian handbook is a few hundred pages of boilerplate language regarding academic life, social life, alcohol policies. And I respectfully suggest to the court that terms of service with a company don't dictate constitutional rights. And, you know, the United States Supreme Court didn't directly get to that issue, but it came real close in Byrd, which was the rental car case. And if the court recalls, you know, rental car companies say that, you know, if you rent a car and you're not the individual who signs up for the car, you're not allowed to use it. And for a very long period of time, it was the law in the United States that, well, you don't have an expectation of privacy if you're not signed up for the terms of service. And so the United States Supreme Court changed that. And so I would respectfully suggest to the court that's an issue. And the court, I would suggest, has put its finger on a very important point.
Hey, John.
These terms of service, these terms of service are written by the lawyers for private entities that are trying to, I guess, preserve their right maybe to interdict illegal activity to protect their own business interests. That's not a waiver of someone's constitutional rights. And so I respectfully suggest, until we get to the point in time, like maybe in the movie Iron Man, where Iron Man can talk directly to a satellite, until we get to the point in time where each of us as individuals have our own internet, our own Wi-Fi service, we have to rely on other individuals to get us to the internet. To allow,
argued in the prior case, in this case, Carpenter dealt with CLSI. If I understand the record correctly and the Carpenter opinion correctly, CLSI is automatically captured by the phone companies if your phone is on. If your phone is not off or in airplane mode, CLSI is captured. And the Supreme Court said, look, the phone in today's world is an extension of our hands. We all carry them. We all use them incessantly. And here, that phone is broadcasting, and there's nothing that the defendant can do about it. This case involves Wi-Fi. I'm 73. I know how to go into settings and turn off my Wi-Fi. Didn't your client know to do that? Didn't your client leave his Wi-Fi on? Leave his Wi-Fi on in his jeopardy. But the real point is that the case is factually distinguishable from Carpenter.
Justice Baer, I'm of course going to answer that question, but if I could just finish and I wrote a note so I get to the second part of the question, but if I could just finish the first part with respect to, you know, did he waive it? Yeah, on the record, and it's on pages R44A and R45A, none of the students are told that they will be geo-tracked. So before Mr. Dunkins can waive anything, meaning waive his right to not be geo-tracked, he really should be told, hey, listen, you know, son or ma'am, if you use your phone on our campus, we are going to track you. If you do anything wrong, if you spit on the sidewalk, if you're disorderly, we're then going to use your Wi-Fi, the little Wi-Fi footprint. We're going to use it and turn it over to law enforcement. That wasn't done. The waiver that he signed was very consistent with, like, the waivers you sign when you drop a computer off at Best Buy, or, you know, the kind of waiver that says if you save child porn on our server or you plagiarize something and you serve it on our server, we're going to be able to turn it over to law enforcement, meaning evidence of illegality. I respectfully suggest that's not what happened in this case.
Counsel, I'm sorry, Counsel Justice Doherty, how are you? I have a very basic question. The issue before this court is whether the trial court erred in denying a motion to suppress under the Fourth Amendment. Your argument is very good with regard to Article 1, Section 8. As we know, the Fourth Amendment is to protect from police abuse as opposed to privacy. Whether he signed the waiver, it's part of the record that he was aware of the handbook and that anything use of your cell phone in the Wi-Fi was being tracked. How is that analogous to police misconduct?
Okay.
Specific to the issue granted, you have a phenomenal argument. If someone had raised the Pennsylvania constitutional violation, it'd probably be a hands down winner. My concern I have is with regard to the Fourth Amendment and how you get around police misconduct when their record doesn't indicate anything.
Justice Doherty, if Your Honor pleases, I'll answer Justice Baer's question, and then I'll hopefully do a decent enough job to allay your concerns when I'm done. So Justice Baer, the issue with turning on and off the Wi-Fi, The problem is that, and again, I'm a 52-year-old guy, and I don't pretend to be a tech expert, but the reality is that raises issues that aren't really directly raised in this case. If the court's starting to make determinations of, well, you should turn your Wi-Fi off, now what the court is doing is the court is making constitutional policy dependent on the manner in which my phone connects to the internet. And for a guy like me in a fancy suit, that's not a problem because I have unlimited Wi-Fi, unlimited cell service for me, my wife, my 3 kids. My dog had unlimited Wi-Fi in his collar where we tracked him. But that raises issues for the poor, minorities that generally don't have the same income level.
Counsel, can I interrupt you for a second? My point, and you're doing a fine job answering questions, but I don't think I asked it, isn't this case distinguishable from Carpenter, given Carpenter's focus on CSLI and the distinguishment between how cell phones broadcast that and the Wi-Fi? That's all I wanted to know.
Yes, sir. I mean, look, I carry the baggage that my client brings with him to court. So yeah, there's no question that these facts are not on all four with Carpenter. What I would suggest to the court is Carpenter is like the first step. This is a more specific step because Wi-Fi is more specific than GPS. And again, in this particular case, it was Wi-Fi campus-wide. And I won't repeat myself, but I would suggest that in this particular case, the record is replete with the fact that no one was told that they will be geo-tracked, and the terms of service shouldn't control constitutional rights. And now, Justice Doherty, I think the court's question was, how did police abuse in this case? Was that? So in this particular case, what happened was there was the robbery. An Act 120 law enforcement officer, and there's been no, the government, the Commonwealth in this case agreed that there's state action in this case. So, the state action doctrine says that if you're acting as an instrument of the government, means that did you know or acquiesce to the search, or was the search done for a private interest? In this particular case, an Act 120 police officer who carried a gun, who had a badge, who was the law on that college campus, went to the university and said, do a search for me because of the robbery. So it's completely different than Atkinson, which is a case that the Commonwealth is relying on. This was state action. In the Atkinson's case, that was a case where there was a robbery at the T-Mobile store, and T-Mobile did the search. T-Mobile did it on their own accord and then gave the information to law enforcement. And there were also some other issues in Atkinson. In Atkinson, Mr. Atkinson didn't raise at the district court level, didn't raise the Carpenter issue, and also in Atkinson, if my memory serves, they never raised the Byrd issue. We have. So I hope that answers the court's question.
Well, I think we've explored the issue in fair depth, so perhaps we could turn to the appellant or the appellee's position.
Thank you.
Thank you. May it please the court, my name is Catherine Kernis. I'm an assistant district attorney in Northampton County, and I represent the Commonwealth of Pennsylvania. I agree with the Superior Court that the defendant here had no legitimate expectation of privacy with regard to his Wi-Fi location data, and that's for 2 reasons. First, as Your Honors mentioned previously, he signed the student handbook, which constituted a waiver of any privacy interest. Much was made by
your opposing counsel said he did not sign it. Now that one's easy. It's either raining or sunny outside. What's the record say?
The record says on page 13 of the suppression hearing transcript, Your Honor, there's mention made of an electronic acknowledgement. That is a condition precedent to attending Moravian College, that you sign that acknowledgement of receiving the handbook. And so there was testimony with that long. Those are printed pages, Your Honors. It's in plain language, although clearly written by a lawyer. The terms that are used are some that could be understood by a college student. And only 6 pages were entered into evidence. But of those 6 on page 3, it says that the information, if you were to use the Wi-Fi, that data becomes the institution's records, meaning that it becomes Moravian College's records. It is also listed as an optional amenity or privilege that can be used by those students to enhance their education while at Moravian College. Here we have a record belonging to Moravian. The campus police asked for what we call the equivalent of a tower dump. It's an indiscriminate search for all of the people who were connected to the Wi-Fi in Hassler Dormitory from 1:30 to 2:30 a.m. At that point, they did not have a suspect in mind. They just knew that a crime had been committed in Hassler Dormitory in the nature of a robbery, and they were trying to find out more information during the course of the investigation.
Counsel, this is Justice Doherty. You just said an indiscriminate dump, yet you followed that by saying they were looking for an individual, AKA a suspect. How is that indiscriminate? It may be you don't know, but this isn't a tower dump in lieu of just a transfer of information. This was a request for everyone who signed on or used that particular internet during a specific time period, which is not indiscriminate. So how do you justify the conflict of your statement?
I think, Your Honor, what I mean to say is that they were not searching for an individual. They knew that a crime had been committed, but they didn't have an idea that Dunkins was the person who had committed that crime. And in that nature, they were just trying to find all of the connection points so that they could have an idea who may have been present at that time. They had no way of knowing if the person involved was a Moravian College student as well. And as Your Honor, I believe it was Justice Baer may have pointed out that this person had to be connected to the Wi-Fi in order to be found. If they were not connected to the Wi-Fi, then it would have been a blank on the record. There would have been no way of knowing that they were present by just looking at the Wi-Fi information. And I think that's another important point here is Appellant, he was signed on to the Wi-Fi. He used his unique individual username and password, which he received at the same time as he received the handbook. And he chose to connect to the Wi-Fi while he committed an armed robbery. He had the choice to disconnect from the Wi-Fi. He also had the choice to turn the Wi-Fi off on his phone. And in doing so, he would have still maintained the function of his cell phone, which makes this case different from Carpenter, in that he still would have been able to use a cell phone for his needs. Even without the Wi-Fi.
I apologize, counsel. If this individual had not been a student, is it your position that the results would have been different, that they would not have been, that the motion to suppress would have been granted such that his status as a student changes his constitutional rights?
I think if he had not been a student, Your Honor, his name would not have been on the record at all because he would not have had a username or a password. I think the other part of the question is that if for whatever reason he was on the Wi-Fi, had somehow obtained a username and password, the nature of the search is also distinct from Carpenter in that they tracked his movements for a 2-hour period, then from midnight to 2:30 a.m.
Did I misunderstand the facts that there were 3 people, 2 women and the defendant, and that the 2 women were not students, or they were students?
I believe they were students, Your Honor. However, they knew from the victims of this crime that the 2 individuals involved were both male. And so they did not search, or they did not look at the information of the female peoples any further.
Well, I believe they put in the record that the 2 female were in a dorm maybe that did not belong to them or where they were not supposed to be.
Yes, that's right.
That's a whole nother invasion of privacy issue, but that's not before this court.
Right. And Your Honor, so I think that in choosing to connect to the Wi-Fi while he committed the robbery, the appellant abandoned any interest that he had in that privacy. As Your Honors have pointed out, there is no PA constitutional issue that's raised here. There was no Edmunds analysis, and any such issue has thus been waived. And I would also agree with the trial court here in terms of the nature of the documents sought. It was similar to a surveillance camera in that they were asking for general information for the time of the robbery, But as our amicus pointed out, it's actually less invasive in some ways than a surveillance camera because we couldn't actually see physically the people involved in the robbery. All we saw was that a phone was present at the time of the robbery. So in other words, we did not see the physical person of Aplt committing the robbery. We just know that his phone was in the building at or around the time of the robbery.
Counsel, this is Justice Donahue. As you described the handbook, there is a notification that one who is a student and uses the Wi-Fi system gives up the data that is generated during use of the Wi-Fi. Is data defined in the handbook to include geolocational information? In other words, is the student or faculty member advised that they are giving up their expectation of privacy as to where they are at any given point in time when they're using the Wi-Fi?
Your Honor, this was an issue that was raised before the trial court during the suppression hearing. The term data is not specifically defined within the handbook. However, the trial court found in looking at the handbook as a whole and after hearing the testimony that data did include geographic location because it was transmitted over the Wi-Fi network. And I think that that factual finding by the trial court has basis in the record.
How does the trial court make a finding that the defendant knew what data meant? I mean, was there testimony to that effect?
No.
What kind of fact finding is that?
I believe that the trial court here it looked at the handbook as a whole and found that any data would include geographic location as it's a connection point maintained by Moravian campus as their own record. Unless there are any other questions, I will rely on my brief. Thank you. I believe the Superior Court's decision should be affirmed.
Thank you very much. Okay, hearing no other questions, we'll conclude the argument and take our usual pause and then call the final case of the morning.
next argument is in re appeal for formation of independent school district, appeal of Middletown Area School District, and appeal of Steelton High Spire School District. Representing Middletown is Mr. Jeffrey D. Litz, representing Steelton High Spire is Mr. Vincent L. Champion, and representing the appellee is Mr. Adam C. Zai.
Good morning. This appeal concerns a petition filed by the High Spire Education Coalition seeking authorization to transfer students residing in the borough of High Spire from the Steelton High Spire School District to the Middletown Area School District. The Secretary of Education ultimately concluded that the petition lacked educational merit, finding that the transfer would materially worsen Steelton High Spire's already distressed financial situation, which would result in educational detriment to the students remaining in the district. The question presented is whether the Secretary may consider the financial consequences of transferring students from one school district to another when determining whether a transfer petition has educational merit. Mr. Litz.
Thank you, Your Honor. May it please the court, my name is Jeffrey D. Litz, and I represent the appellate Middletown Area School District. As noted earlier, with me today is Vincent Champion, the attorney representing Steelton High Spire School District. Pursuant to your order granting our joint motion for the division of oral argument, I will be addressing two arguments before turning over to Mr. Champion. I will be addressing why the Commonwealth Court erred in failing to follow its own precedent in Regalsville 2. The second argument I will be addressing is why the Commonwealth Court erred in failing to follow this honorable court's decision in Weberlin. Once I've completed those arguments, Mr. Champion will address what is the appropriate standard the Secretary should employ when reviewing transfer petitions under Section 242.1, why the Commonwealth Court erred in holding that the Secretary usurped the Court of Common Pleas role in apportioning debt, obligation, and subsidy under that statute, and then finally why the proportionate financial impact of the proposed transfer on Steelton High Spire School District is an appropriate consideration for the Secretary.
Are your interests aligned? Are the interests of the two school districts aligned?
Absolutely, Your Honor. At this stage, they are.
And they both present what universal position with regard to this transfer of students?
Yes, sir. Absolutely.
What's the position?
The position is we both oppose the transfer, and we believe that the Secretary correctly erred that this proposed transfer lacked educational merit for the reasons articulated in his decision.
Thank you.
So with regard to the first argument, it's our position that the Commonwealth Court erred in failing to follow its own precedent, which is its 2011 Regalsville decision. In that case, with a different petition for transfer, the court held that the Secretary's review is restricted to substantive provisions of the Public School Code and must be guided by policy choices made by the legislature as articulated in the school code. That's the standard in Regalsville too. And they use that standard in granting a request to transfer a portion of Regalsville Borough between the Eastern Area School District and the Palisades School District to eliminate discontinuous boundaries for the Eastern School District. This was an island of itself away from Easton, and they found that was a substantive school code provision to support that. Also in Regalsville, too, they cited two earlier Commonwealth Court decisions, the Hamlin and Sargent Township case and the Brady Township case, to illustrate what they also felt would be educational merit, and it was reducing travel time for kids and then having closer schools, newer facilities, and better school district management. So that's what was articulated in Regalsville, too. We would submit, Your Honors, that the Secretary of Education's school financial policy concerns, as articulated both in the initial pre-adjudication deliberations and in the Secretary's final order, are no less substantive, no less grounded in the school code than what was articulated in Riegelsville 2, and the case is cited therein. The General Assembly has made very clear that financial issues and having appropriate resources for public school districts is important. The Secretary pointed out that the school code requires districts to submit reports about their audit, their annual audit. They're required to submit reports about their debt. We have a provision in the school code, Article 6A, that is specifically designed to assist financially distressed school districts. And as I noted in my brief on page 15 in a footnote, the General Assembly has promulgated legislation dating back to the 1950s designed to assist financially distressed districts. And Steelton High Spire has been placed on the watch list under that particular statute. So it's very clear that the Secretary showed fidelity to Riegelsville 2, articulated the statutory provisions within the school code to demonstrate that the school financial concerns that he has expressed are consistent with that decision. And therefore, I would submit that the court erred in failing to follow its own precedent. Additionally, in that case, in our case here, the Commonwealth Court used the definition edition of education to refer to a course of study, learning, instruction, or training. Well, if you take that standard as articulated and try to apply it to its decision in Riegelsville 2, fixing school district boundaries has nothing to do with the course of study or learning or instruction or training. They just are not showing fidelity to its own precedent. And I think if the court simply stayed with its precedent in Riegelsville 2, it would have found that the Secretary acted appropriately in this case. The second argument I'd like to make, Your Honors, deals with this court's decision in Weaverland from 1954. It dealt with an earlier statute, but as the Commonwealth Court has explained, and I think the PSBA amicus brief did a good job giving sort of the legislative history of this, it was sort of the predecessor statute for transfers of territories between school districts. And the Commonwealth Court specifically found in Riegelsville 2 that Weaverland was the leading case on the statutory meaning of the phrase merits from an educational standpoint. And that identical language is carried over from the statute that was addressed in Weaverland to what we have before us today under 242.1.
Counsel, could I ask you a question on that? Pardon me, Mr. Litz, since you just cited Weaverland. Weaverland said the Secretary, quote, must determine whether on the basis of his expert knowledge in the field of education, et cetera, et cetera. My question for you that arises there, that germane to this case, I think, is what is the standard of review over the Secretary's decision? In other words, is the Secretary's decision based upon his or her expertise in education essentially unreviewable?
So, Your Honor, with regards to the statutory meaning of the phrase from an educational standpoint, that is a matter of law that you guys, or I apologize, the Honorable Court gets to decide for itself. You're the final arbiter as to that. Assuming the Secretary is acting within the confines of those parameters, it's an abuse of discretion standard when you review the Secretary's determination, as in any administrative law case. And therefore, the Secretary's decision would be reviewable just under that standard.
So what is the, just brief follow-up, what is the textual basis for I guess, your suggestion that the Secretary's review encompasses, I guess, more than the, well, I'm struggling to express this. Let me just put it this way. That review that you just articulated for us, or for the courts generally, how are we to, what criteria are we to employ to ever be able to second guess the Secretary of Education's testimony about what the educational merits are? I don't know what the yardstick
would be.
Yeah. And that's why you took this case. I mean, there are clearly guardrails that the secretary must stay within when considering these matters. I know Mr. Champion's going to speak to this, and I don't want to take away from his argument, but briefly, I think one step is the Regelsville 2 case is saying that the secretary must be able to articulate substantive concerns as found in the school code is a good benchmark to start, and that doesn't give him unfettered discretion. Secondly, with regards to Weaverland, this court in that case talked about expert knowledge and the advancement or hindering of public education. And again, I think those are good general guideposts that the courts can use in determining whether or not the secretary engaged in abuse of discretion. The other thing I would share, Your Honor, is that the process that currently exists permits for an evidentiary hearing before the secretary after the issuance of the predetermination adjudication. And therefore, all of the parties have the opportunity to submit evidence and testimony. In this case, we did it by stipulation. But the secretary's findings, of fact, need to be substantiated with appropriate evidence. And again, the legal conclusions need to be in compliance with the applicable statutes in court cases. So, yes, is there a level of deference that may be different than in other settings? Yes, but I don't think it would permit an unfettered, abuse of the secretary's ability to just make a decision that you couldn't review.
Well, Mr. Litz, Tom Saylor, well, let's start at the beginning. This is a delegation. The legislature allowed for this type of event, the changing in school districts, but it delegated to the secretary, an administrative official, that the discretion to effectuate the statute. So you first look in the delegation system as to what guiding principles it gave the secretary to constrain his exercise of a legislative delegation, and did it. What guiding principles did it tell the secretary that he or she could consider?
So the statute talks about merits from an educational standpoint. In Weaverland, well,
that's pretty broad. I mean, that sounds like a very, very broad discretion.
Yes, and
usually in a non-delegation case, you have to have some specific earmarks, or the legislature's abdicated its constitutional role.
Yeah, and so when this similar situation came up in Weaverland before this court, they suggested the unlawful delegation had to stick within school considerations, and none of the parties in this case have questioned that the secretary is unconstitutionally fulfilling a role in entertaining the petition and rendering an opinion as from an educational standpoint.
I understand that. Well, let me ask you to get to the nub of the thing. If you use this this financial element rather than the educational component, how can parents ever move children from a school district to a better performing school district if you have to overcome the notion, well, then that would in some way cause the rendering school district to suffer financially? Why is that a relevant consideration in considering what's best for the children that want to move to a better performing school district?
Well,
how could they ever get out?
I think it's relevant in two manners, Your Honor. Again, with the Weaverland case, this court said the secretary is supposed to use their expert knowledge in the field of education to consider whether education in the entirety of the area to be affected would be advanced or hindered. Every transfer case is unique, so financial consideration is not going to be an issue in every single transfer case. It's going to depend upon the facts and circumstances.
Well, this is a distressed school district. You can never get out of it. So there's under the secretary's position, I don't see any way these children could ever move to the other school district.
Well, I would submit two things, Your Honor. First, under the Weaverland case, the Commonwealth Court totally disregarded part of the analysis to consider if anyone's education would be hindered. And the Secretary and the Deputy Secretary at length articulated the concerns that the Steelton Borough school children education would be impaired because there wouldn't be sufficient financial resources to support a thorough and efficient education for them. Second, since 242.1 was adopted in 1965 and then amended in 1967, there have been further changes. And there are public school choices that are available to all children in the Commonwealth without additional cost if they don't want to go to the Steelton High Spire School District. We've passed a charter school law that allows students to attend charter schools. That was further amended to allow for cyber charter schools. And the record shows in this particular case, Your Honor, at the Secretary's finding of facts 40 and 41, that there are High Spire students attending non-public schools and charter schools. So there are choices.
Mr. Letts, one final question, and I don't mean to dominate this and I'm done, but it would be easy for the legislature to say, consider the following things, including the financial effect, but they never said that. They're talking about the educational benefits.
Well, I would agree with Your
This all
Honor
comes
that
from the legislature. This isn't the Secretary's creature.
I would agree with you, Honor, that the legislature, if it so choose, could revise 242.1 to articulate more precise standards than what is currently in the statute. That said, the Secretary relied upon the precedent of Riegelsville 2 to stay within the substantive provisions of the school code, as well as in this court's decision in Weaverland about using his knowledge of the public education students and weighing the interest between advancing and hindering public education. So I think that the Secretary stayed within the legal parameters that are currently set forth. If the General Assembly wishes to modify that to reduce the scope of the Secretary's review, that's within their statutory purview to do that, but they have not elected to do so. Very briefly, but then before I'll turn it over to Mr. Champion, I think the Weaverling case reflects a portion of the standard that requires a holistic view of a proposed transfer. That means we have to look at how it impacts everyone, and that's not what occurred in this case. This was, the Commonwealth Court gave a myopic view looking at one small subset of school children and only looking for the betterment for them with total disregard to the impact on my client as well as the folks in Steelton Borough. So unless there's any further questions for me, I will turn it over to my co-counsel, Mr. Champion.
Counsel, it's Justice Donahue. I'd like to follow up on the last point that you made. Has this court ever held that it is the educational merit as to both the transferring students and the students left behind that the Department of Education has to take into account?
No, the only decision out of this court that touches upon the statutory language issue here is in the Weaverling case. They use the phrase that the review should consider advance or hinder educational facilities because it dealt with transfer facility for facility reasons. So that's the only language that's come out of this court with regards to that. Mr. Champion is going to speak in his arguments about what we believe should be the appropriate consideration for all parties, and I'll let him address that question in greater detail if that's okay, Your Honor.
Okay, let me just follow up on a point that the Chief Justice made to see if you could help me understand this. Your opposing counsel argues the Chief Justice's point, which is nobody could ever get their children out of a distressed school district. I mean, they're stuck there. And I'd like to test the accuracy of that statement. Here, a specific school facilities. So my question to you is, if a transfer out of a system, out of a school district, such as the High Spire School District in this case, resulted in a situation that would allow for consolidation of buildings, consolidation, and therefore reduced costs attendant to the district being left behind, then in fact, it might result in a situation where there is a benefit to be derived by that school district that's left behind and just happens to be financially distressed.
I would agree with that, Your Honor. The unique issue and problem in this case is largely due to the size of the Steelton High-Spire School District. It is so small, and we're talking about a removal of a substantial percentage of the public school population, roughly 18%, that the economies of scale don't allow for the type of savings that you're articulating. So yes, I would agree with you. That possibility exists in another case.
So it's really, in large part, a function of the size of the transfer that was taking place here that had the deleterious effect on the school district that was to be left behind by the proposed transferring students.
That is a huge factor, Your Honor. I would agree.
Okay, thank you.
Okay, I'll turn it over to Mr. Champion. Thank you, Your Honor.
May it please the court. My name is Vincent Champion. As Mr. Litz indicated, I'm arguing on behalf of the appellant Steelton High-Spire School District. My argument will address three main areas. First, the proper standard the Secretary of Education should use when reviewing transfer petitions pursuant to Section 242.1 of the School Code. The second, why the Commonwealth Court erred in holding that the Secretary's financial impact analysis encroached upon the statutory purview of the Commonwealth Court of Common Pleas. And then finally, Your Honors, why the catastrophic financial impact of the proposed transfer on the Steelton High-Spire School District is an appropriate consideration for the Secretary's educational merits analysis. Currently, there is confusion regarding the parameters of the Secretary's role in determining whether a petition is meritorious from an educational standpoint. The Secretary below attempted to apply the standards set forth by the Commonwealth Court in Regalsville 2, but was ultimately rebuffed when the Commonwealth Court wrote that the Secretary's understanding of educational merit shifts with each transfer petition. The Steelton High-Spire School District respectfully asserts that this court should help eliminate the apparent confusion by adopting a uniform standard to be applied. Historically, the Secretary has considered the merits of a petition from three perspectives and ultimately determined that a transfer will not be approved when a negative impact upon the education of any of the student groups is anticipated. This approach, as Mr. Litz has indicated, has at least been tacitly accepted by the Commonwealth Court in Washington Township and initially in Regalsville 2.
And in Council Justice Barrett, if we specifically adopt that, and I actually think you're probably correct in all candor, but it brings you back to the Chief Justice's situation. No group of parents are ever going to try to move their children from a superior to an inferior school district. They're always going to aspire to move their kids from the inferior district to the superior district, which is what's occurring here. If it's the law that you consider the impact on the transferee district here, Steelton, then the Chief's point is that all of this is an illusion because no child can ever move. Now, how do you respond to that?
Certainly, and thank you for the question, Your Honor. This is not a scenario where there is a blanket rule where if a school district is in a financially distressed school district, or if the school district has inferior, I guess, as far as it relates to this case, inferior testing results, that a group of students, by operation of their parents' actions, wants to move to a different school district will ultimately be prevented from doing that. There are a number of scenarios where a school district seeking to leave pursuant to 242.1, where that scenario could ultimately be approved. I think it was suggested earlier that the real issue with regard to this case is the proportional size of this transfer. And what the secretary directly noted in this case is that it was this instant transfer was one of the largest transfers in recent memory. And what made it so, I guess, objectionable is the size of the school district. The school district is approximately 2 square miles. The students that reside within the borough of Highspire constitute 18% of the student population. More importantly, the tax revenue associated with the real estate taxes and the associated with the real estate taxes comprise 30% of the tax revenue of the school district, and then the earned income tax revenue comprises 40% of the tax revenue. So when looking at the size of the school or the proposed transfer in this particular case, I think the factors compel the finding that the impact of the proposed transfer on the students that remain would not support such a transfer. But in response, this does not create a blanket rule, frankly, that a transfer can never occur in this circumstance.
Well, apparently, and I should have asked Mr. Litz, apparently Middletown didn't want the students either. Is that right? Is that correct?
Yes. Your Honor, we opposed that, and it as was found by both the Deputy Secretary and the Secretary, a primary concern that we had is we might not be able to house the students. My client had built a brand new high school that had been in the planning stages before this transfer, and there was a clear finding in the record that we could be straining our facilities at the elementary level. We might not be able to house 360.
Thank you. Thank you. Okay, Mr. Champion, I didn't mean to interrupt your read.
So in this case, the Commonwealth Court, at the urging of the coalition, limited its analysis to whether the petition advanced the public education of only the students living in Highspire, focusing mainly on test scores. As set forth in the Stilton Highspire School District's underlying brief, the district believes that when applied properly, the guidance set forth in Regalsville 2 is a good starting point. Specifically, when the secretary exercises his or her discretion to determine whether a proposed transfer has merit from an educational standpoint, he or she should be guided by the policy choices made by the legislature in the school code, and not by their own personal sense of what constitutes good education policy. The Stilton Highspire School District respectfully further asserts, in recognition of this sound guidance set forth by this court in Weaverly, the standard should also be expanded to expressly include the requirement that the secretary must consider whether, on the basis of his or her expert knowledge in the field of education, the proposed transfer hinders or advances the education of the students within the 3 separate groups affected by the transfer: students within the territory proposed for transfer, students remaining in the district, which would constitute losing territory, and then finally the students in the district which would gain the territory.
Counsel, could I jump in there, Counsel?
Yes, sir.
That certainly sounds entirely reasonable. My question is, what's the textual basis for it? I mean, the problem for all counsel in this case, I think, and for the court, is the General Assembly has never come back and amplified the statute. They've just said merit from an educational standpoint, and petition shall not be granted unless approved by the secretary. So, I mean, that's a breathtakingly broad delegation with no standards provided. There's no delegation challenge in the case, but where is the textual basis for your reasonable argument about looking at all three groups?
Yes, certainly, Your Honor. And I think Your Honor is exactly right. The statute is extremely broad, and the legislature has left for the Department of Education through the Secretary of Education, and then subsequently the courts to fill in the gaps in terms of providing the necessary specificity. In terms of the textual basis, that's really been a development over the historical approach that the Secretary has utilized in really trying to come to terms with how it is that it interprets that provision within Section 242.1. So you're absolutely right, Your Honor. There is no express language relating to that, but this is the development of the law as the Secretary has applied it over the course of the years in trying to apply this section.
But Counsel Justice Fair, I thought the whole point of the Weaverland decision was to rebuff the non-delegation argument. And it said that the Secretary has to look at the public school code. And the legislature, the public school code, has set forth what it believes is important. And that guides the Secretary. Now, I don't disagree that that's still broad and amorphous, but that's what saves us from non-delegation, isn't it?
Yes, it is, Your Honor. I think that this honorable court has already anticipated that issue, has already addressed it, and has given the future, I guess, litigants under this section guidance on how to make sure that the non-delegation potential issue can be avoided. And that's certainly by...
And in this case, just by happenstance, because the school district's getting into financial trouble, there's substantial law indicating in the public school code that the legislature is deeply concerned about the fiscal health of school districts. And that, again, buttresses your argument. Can I ask you something? I was going to wait and ask the Aplt. I didn't, but I'm interested to get your insight. I didn't respectfully understand very well the Commonwealth Court's opinion, because it said you cannot consider financial resources. But literally everything in a school district, it seems to me, is financial. You set the temperature on the wall at a certain degrees premised upon your heating cost and your students. You replace your band uniforms, you replace your books. You have 20 or 25 or 30 kids in a class. It seems to me that every decision that a school board makes is guided by its finances, whether it's a wealthy or a poor school district. So I didn't understand how the Commonwealth Court said you can't consider finances when everything you are considering is indirectly money. Now, do you have any insight on that? Again, I was going to ask the Aplt, but I thought I'd give you a chance because we don't have rebuttal.
And thank you for that question, Your Honor. Like you, I have frankly have been struggling for years as to how it is that you can reconcile the inextricable partnership of proper funding and providing educational programming for students. They are intertwined. They are intertwined at the hip, and you cannot provide adequate educational programming without proper funding. So I would suggest that you cannot separate that. And I would agree with the Secretary's analysis that it's appropriate to consider the financial impact of a proposed transfer on the district's ongoing ability to provide the foundational obligations of a school district, and that's to provide adequate educational programming.
Counsel,
Thank you, Mr. Kim.
Chief, can I just ask
sure.
one follow-up question? Counsel, I wanted to talk to you a little bit about what you think the Commonwealth Court held in this case, because I think we may have a disagreement. I too agree with the proposition that some clarity from this court on the scope of the measurement of educational merit is in order, i.e. that it impacts both the transferring and the district left behind. But I think the Commonwealth Court has held that in the past in Washington Township. And as I read the Commonwealth Court opinion in this case, it's much more black and white. They're saying that the only educational merit that was established here was in favor of the transfer because the kids who would be transferring would be benefited. And there was no educational merit analysis as to the district that's being left behind because financial considerations is not a function that goes to educational merit. Would you agree with that analysis?
I would agree that the Commonwealth Court's decision clearly, at least in my mind, indicated that the financial considerations are separate and apart from the educational merit analysis. In reading Washington Township, I agree, Your Honor, that Commonwealth Court at least tacitly approves that approach, but there is no express language that effectively endorses the what we think is a well-reasoned position that all aspects of the proposed transfer, all those students that will be impacted need to be considered. Perspectives need to be considered. So that my reading of the Commonwealth Court case is a little narrower in that the court clearly pushed, at least from my view, Your Honor, pushed aside any consideration of finances in terms of the educational merits analysis.
Right. I agree. Thank you.
Thank you. We'll hear from Mr. Z.
You're on mute.
The High Spire Education Coalition. Can you all hear me? I just saw a notification that I was unmuted. Okay. Good morning, everyone. My name is Adam Zai. I am an attorney representing the High Spire Education Coalition in this matter, and we are the Aplt. The heart of this case is really the protection of one of the most important foundational elements of our society, which is our children's right to receive a thorough and efficient education. In its review of the Secretary's denial of the Coalition's petition for the formation of an independent school district, the Commonwealth Court carefully considered, acknowledged, and remained consistent with its own prior relevant decisions, while also applying the precedent of this honorable court to overturn what is quite frankly an unsupportable decision by the Secretary of Education that would have improperly expanded the scope of review given to the Secretary by the legislature in Section 242.1 of the school code. The Secretary's decision went well beyond the ordinary meaning of what educational merit would encompass, and would have not only resulted in the children of High Spire being denied an opportunity for a better education, where Steelton High Spire has objectively demonstrated failure to deliver that to its own students, but also preemptively nullifying the possibility of any transfer of students, as this court has pointed out, from one school district in financial peril to a different school district, absent the transferee school district consenting.
Could I ask you?
The Commonwealth Court, excuse me, yes.
Yeah, sorry to interrupt you, but I have a question on that. What is the textual basis that would direct us to evaluate educational merit solely as it relates to the students who wish to transfer, particularly given that the Secretary is not the Secretary only of High Spire, but is the Secretary of the Commonwealth? In trying to grasp some handhold, some foothold, as it were, in this incredibly broad and vague statute that the General Assembly has refused to update, I'm left to wonder why we are not compelled to look more globally than just High Spire Borough, given that he or she is the Secretary of our Commonwealth and not only of your borough.
Your Honor, I believe that the textual basis is obviously what the legislature has delegated to the Secretary for his consideration, being the educational merit. That phrase, educational merit, has been left up to the court to decide, with this court having determined that the phrase should be given its ordinary meaning. Within the definition of that ordinary meaning, that's what the Commonwealth Court sought to do, was provide that clarity of what encompassed the educational merit that the Secretary was tasked with determining. And I think it's also critically important to remember that this is a multi-step process, and the Secretary represents only the first and one of multiple steps, with the apportionment of individualized debt and subsidies to be afforded to the students that are transferring, as well as those students that are being left behind, left to the common pleas after a determination of educational merit. Inherently within the sequencing of that review, there is a limitation that is placed upon the Secretary's review so that it doesn't render subsequent steps in this process either redundant or irrelevant. The position that the Secretary's decision has taken would effectively do that by acknowledging that there's a multiple step process and that the Court of Common Pleas, as well as later on the Board of Education itself, would have to have the ability to weigh in independently on those aspects of this petition or in any petition that would be delegated specifically to them. And as I said before, the Secretary's decision would improperly expand the scope of his review to start taking from those other entities items and areas of review that were specifically delegated to them.
I don't. Counsel, in follow up in that argument, the Court of Common Pleas in the next level review does not have the ability to transfer taxes from one school district to another, correct?
It's in charge of determining what is the correct apportionment representative of the students who are going to be transferred, and as far as how the debt associated with those particular students or the subsidies associated with those students should be apportioned between the old school district and what should be relieved, as well as what should be transferred to the new school district for receipt of those monies associated with the students, and the timetable and scheduling for when that should occur.
So they can't transfer taxes?
I'm not sure I'm following, but the students would be continuing to reside within their own taxable area, and then how those taxes were utilized would then be what would be in front of the Court of Common Pleas for determining how that should be apportioned and when that apportionment should occur.
The Common Pleas Court apportions subsidies and debt.
Correct.
Not taxes.
Correct.
Correct. And of the multi-level financial analysis that took place through the consultant that was hired by the department, they took into account many various financial scenarios, most of which were based on the predicate that given the size of this transfer, huge portions of taxes that support the High Spire School District were going to be essentially moved into the transferring district. So to your point that the Secretary was usurping the function of the Common Pleas Court, that's not true in the context of taking into account these multiple tax loss scenarios.
I believe Your Honor would be correct in that the Court of Common Pleas is not charged with the authority to reallocate taxes. However, that's also the Secretary's position and reliance upon the financial report prepared by PFM is also operating from a potentially misleading, if not false, predicate, which is that Steelton High Spire is functioning properly with these students. As the Secretary found, this perpetual state of financial peril and distress that existed prior to the petition being formed and will continue to exist after the petition is resolved is not the fault of these students. And effectively what the Secretary is doing is attempting to draw an arbitrary line of what amount of subsidy and borrowing and overspending and failure to meet its financial obligations on an annual basis is sufficient, which isn't the Secretary's authority. That's something to be determined by the legislature in apportioning and determining what funds and subsidies should be available to those school districts. There's two separate components. The Secretary is attempting to conflate them so as to support a conclusion that this is the petition is going to be representative of what triggers a unsustainable financial position for Steelton High Spire, when the reality is it's already in a financially unstable and unsupportable position.
Yeah, the Secretary did not suggest otherwise.
Correct. Secretary admitted as much.
So, I mean, your position that he asserted an unsupportable, untenable position is just not supported by the record. He said precisely what you said. They're in bad condition now, and they're going to be in bad condition whether or not the transfer takes place.
Correct.
I know that from his findings.
Correct, Your Honor.
Counsel Justice Baer, I want to take you back to Justice Weck's question, because I don't think I heard an answer to it. So let me make it really narrow, and you pick column A or column B. Is the secretary under this statute to look at the educational merit of Pennsylvania or of High Spire students?
He's to look at the educational merit of High Spire students and those students impacted by this potential transfer, with a particular focus on the High Spire students, because they're the only students who are going to be existing in one school district and transferring to another. So if you are to be looking at the...
Let me stop you, because respectfully, that's gobbledygook. Does he look at the Higher Spire students, or does he look at the High Spire, Steelton, and Middletown students?
I believe he's looking at the petition that's in front of him, which would encompass, as I said, the High Spire students, but with attention being given to their current existence within Steelton High Spire, as well as their potential future existence within Middletown. So there's going to be review of all of them, but his focus should be on the High Spire students, because that's the actual subject of the petition that's before him for his determination.
And that's what you want us to write, because you somewhat just made that up. There's nothing in the law that says, look at the three different groups of bodies, but give some preference to the ones that want to transfer. And
correct. Our position, yes, Your Honor. That's why we are here today, is because the Commonwealth Court is looking at whether or not the Secretary expanded the scope of his review, and they determined that his review did exceed the scope of what he was authorized to do by the legislation.
And again, however, not in the way you just suggested, and I don't want to fight with you. What the Commonwealth Court said was you considered financial matters, and you should not. Now, there's two, and I said to your opposing counsel, there's two problems with that, it seems to me. And the Commonwealth Court always does a wonderful job, but I'm not sure it didn't miss the mark here. The first is that the school code considers financial matters so deeply. And second is that I don't understand the distinction. No matter what factor would influence a school district, it still comes back to money, as I suggested to your opposing counsel, be it the number of kids in the class or the books you buy for them, or whether you air condition your building. It all comes back to money.
Yes, Your Honor. But again, the Secretary's decision is that the removal of the High Spire students would, in the Secretary's words, puncture a irreparable hole. What is reality is that the Steelton High Spire School District is in an unsustainable position, and was before and will continue to be after. So it's a false narrative to say that the petition and the proposed removal and transfer of the students is what would create an untenable position. And that's why I said earlier that by doing so, the Steelton High Spire School District already can't manage its own finances effectively to provide the education that's been asked of it to provide to its students. It's continually requesting advances for subsidies. It's continually mismanaging its debt. And for the Secretary to say that the transfer is what's going to affect it ignores the reality that it's going to continue, as the Secretary admits in his decision, with or without them. So to hang your hat on a determining factor and then also admit that it really is irrelevant to the petition in terms of its creation and continued existence undermines the Secretary's position that the financial impact is what's critical for the determination of this matter.
Counsel, just briefly, under your interpretation of the statute, as a practical matter, wouldn't the Secretary pretty much have to grant all of these? I mean, assuming they establish contiguity, get the signatures, and don't do a completely shoddy job of showing the alleged merits for them, just for the transferee or transferees. When would the secretary ever be within his or her rights to deny the transfer?
I believe, Your Honor, where you would look at a position where, or petition, excuse me, where there would be a corollary between the educational academic opportunities that are afforded to each of the former school district and the proposed new school district, where there was really a negligible difference, then the secretary would be able to conclude that there was no real better educational outcome because of the similarity between, or educational merit because of the similarity between the programs and educational opportunities offered to those students, if none of the other factors that have already been articulated, like you said, Your Honor, which is discontinuous boundaries, limiting or encouraging busing. So those factors can exist separately and independently of the educational merit as it pertains to academics. But if a scenario was presented hypothetically where the academic performance and the educational environment that was provided to students in both school districts was comparable, then the secretary could find, in theory, that there was going to be no educational merit for the transfer because it wasn't going to be addressing any of those other factors. In this case, that's not what's happening, where you have a clearly, objectively deficient school district that isn't meeting the standard for what is to be provided to its students, and you have a proposed transfer school district that is and has a history of successfully preparing its students to be well educated and set them up for success later on in life.
Thank you. Thank you very much, and thanks to both councilmen. With that, we'll conclude the argument and recess to approximately 1:15.